So again, thank you, Mark, for the opportunity to present today. I will try to stick to my 18 minutes for this sort of TED-length talk. I'm really giving quite an early stage overview of something that I'm working on at the moment. Essentially, I'm going to be trying to make a core claim, which is that for the sake of privacy law, we should not necessarily distinguish between real and fake data. Now, I've put real and fake in quotation marks because those of you who are more data literate than I am will know that those are potentially contentious terms anyway. There's always an element of artifice in the way that data are processed and generated and constructed. But I'm really trying to think about this in terms of a privacy, and in particular for today, a data protection approach, because the literature, policy literature, academic literature at the moment, tends to split up fake data into almost like a discrete set of problems: synthetic data, deep fakes, profiles, AI generated inferences. And at the moment, we've got this quite sort of piecemeal approach to regulating fake sort of AI generated data, as if they were all different entities that pose different problems. And I actually tend to agree with Daniel Soloff, who I've quoted on this slide, who says that AI largely exposes long-standing shortcomings, infirmities, and wrong approaches of existing privacy laws. In the context of at least sort of UK, EU, European data protection law, I would say the relevant infirmity is the lack of explicit definitions. Most of data protection law, in terms of its scope, material scope, relies on the concept of personal data. And personal data is information that relates to an identified or identifiable natural living person. But there's nothing really explicit within the legislation that tells us what relate to or identifies means. And that has meant that we have relied on some case law for definitions of what identified, identifiable, relate to means. But the case law is pretty scanty. So we often rely on regulatory guidance to try and fill in the gaps. But even then, as I said, the regulators tend to have so far have had quite a piecemeal approach to AI generated data. Hence why today I'm suggesting that there's actually a little bit of, in my view, deeper conceptual work that's needed to think about what relating to means and what identify means. And if we do that work, actually these definitions could reveal themselves to be technology neutral. That actually, if we really think about what it means to be identified, or what it really means for information to relate to someone, it's not necessarily dependent on how that information was generated, what kind of technology or process was used to generate the data. What really matters, in my view, is impact. And I will be explaining over the course of the next 15 minutes or so what I mean by impact. So for the majority of my presentation today, I'm going to be thinking about what I'm calling scenario 1. And at the very, very end of the talk, I will get to scenario 2. But scenario 2, unfortunately, given the time constraints, is more of an afterthought and a sort of brief counter argument. So scenario 1 is person A, who has a non-consensual intimate image of themselves uploaded on a porn site. They haven't uploaded it, it's been uploaded by somebody else. There's no evidence of their explicit consent. So my kind of introductory question is really, from a privacy perspective, does it really matter if that image was taken with a camera or if it was generated using AI? So that's kind of how I'm getting to this broader point of, do we need to think beyond real or fake data? So I'm actually going to start with criminal law rather than data protection law, because I think criminal law has evolved faster in this area, at least in the UK. There's been more parliamentary debate about this issue in terms of criminal law than there has been in terms of privacy law. This question of how do you mitigate harms, dignitary harms violation based on real imagery and fake imagery. That debate has taken place more in the context of criminal law than it has in privacy law so far, which I do believe is an oversight. In terms of the updated Sexual Offences Act 2003, there are a number of offences under Section 66. It's been it's been updated to Section 66E and beyond. So there are offences relating to creation, sharing, different types or motivations for sharing. But essentially, Section 66B, there is an offence of sharing an intimate image which either shows another person or appears to show another person without their consent and without any reasonable belief in that person's consent. And the legislation does make it clear that the definition of a photograph or film includes AI generated or manufactured images. So basically, in terms of criminal law, we have already arrived, I would say, at a relatively technology neutral place, because I would say criminal law is mostly focused on consequences and harms to individuals. And so I think there's already been that recognition that in terms of harm to a human being, it doesn't really matter fundamentally whether the image was taken with a camera or generated using software, in terms of the impact that that disclosure will have on them. And I think I'd probably go as far to say that if there was any implicit idea that an image taken with a camera is somehow more likely to be consensual than something that's deepfaked, that belief or that misconception clearly doesn't exist in criminal law, because both are really treated equally. In terms of data protection law, in terms of the current guidance that I can find for person A, there isn't anything that I'm aware of at present that would address their scenario explicitly. The Information Commissioner's Office, the UK data protection regulator, has guidance on synthetic data, but that's very much what it's within the privacy enhancing technologies guidance. So it's very much thinking about synthetic data as a privacy preserving technology, rather than thinking about fake data as a privacy violating technology. So there's very little, well, there's nothing in this particular bit of guidance about data that's been generated to violate someone's privacy. It's very much thinking about data that's been generated as a data minimizing, privacy preserving alternative to using real data. So the ICO's current guidance does say, under the question, is synthetic data anonymous? Or I suppose the converse being, is synthetic data personal data? They currently say this depends on whether the personal information on which you model the synthetic data can be inferred from the synthetic data itself. So in other words, their focus is whether synthetic data or fake data reveals real data. And they don't explicitly address the point of whether or not the synthetic data could be personal data in and of itself. If anyone were to receive this personal data and view it as authentic, and view it as a real representation of this person, would that be in and of itself enough to constitute an identification, to relate to that person? And I think that is the thought process that is currently missing from the guidance that I'm suggesting that we should be starting to implement more in practice. Yes, obviously, inferential attacks, warrant consideration in a sort of privacy preserving context, when you've generated synthetic data for the sake of preserving someone's privacy. But when data have been generated using AI not for the purpose of preserving someone's privacy, but for the opposite reason. I don't think you even need to be thinking about, well, does it reveal something real about this person? I personally think it's enough that someone could view that image and see it as real. I think the criminal law approach of appearing to show, purports to show, should be enough for privacy law, because I think privacy law and criminal law are both founded in the same kind of right to freedom from dignitary harm and abuse. So I'm going to unpack that a little bit more in terms of why I'm saying that both privacy law and criminal law are founded in this kind of right to dignity and psychological integrity. Essentially, I mean, in a piece of work, a book chapter that I've written with Elaine Mackey, who's also in this network, we acknowledged the fact that, as Claire Sullivan's written, identity has often been a nebulous notion, and that in referring to identity without defining it, much legal literature lacks precision. It gives the impression that identity is identity, whereas she says the constitution, function, and nature of identity depends on context. I think I agree with that. I would say that in the context of privacy and data protection law, we should understand identity as information that is sufficiently associated with a person that has the potential to impact on their privacy, and that we should understand privacy broadly in line with the breadth of the right to privacy. And importantly, and this really is not particularly speculative as part of my argument, the idea of relating to an identified or identifiable natural person, that's already a very broad concept in data protection law. That has already been clarified by EU case law, that information relates to a person by reason of its content, purpose, or effect. Now, all three of those are important, but for the sake of my current argument, it's really effect that's particularly interesting. The particular judgment this comes from was about exam scripts. You know, is your exam paper your personal data? Because at the time there was some lack of clarity in the sense that it's not about you, it's not a representation of you, it's about history or geology or whatever it was the exam is on. So on one analysis, it's not your personal data because it's not an image of you, it's about something else in its content. But because under this three-part test that the EU court set out, content, purpose, and effect are all important. And in terms of effect, in this case, they said, well, the use of this information, i.e. the exam paper, it's liable to have an effect on the student, the candidate's, his or her rights and interests. In this case, you know, it can impact their ultimate grades, their employability, their academic profile. It can actually have quite a lot of impact on them, and therefore it deserves to be considered personal data because of its because of its potential for impact. So in terms of why I say that we should understand the idea for potential for impact broadly, ultimately this comes down to the breadth of Article 8 of the European Convention on Human Rights itself. So it's the right to private and family life, which is almost a contradiction of terms in and of itself, because it's both about privacy and separateness and autonomy and individual autonomy, but also about connectedness and social relations. And I think the way the court, the European Court on Human Rights has put it itself, you know, they said the concept of private life is broad. It's not susceptible to exhaustive definition. It covers physical and psychological integrity, elements of a person's social identity, ethnic identity, personal development, the right to establish personal relationships with other human beings, and also elements relating to a person's image. And I think time was, as a lawyer, where I might slightly have despaired at the breadth and amorphousness and nebulousness of this definition and said, well, of course, privacy doesn't function well because we've got such nebulous concepts. But I think over time I have come to appreciate more that this is a feature rather than a bug. It's actually a strength rather than a weakness, that the nuance of the right to private life is that it tries to encapsulate all of the conditions necessary for human dignity and human flourishing. So in terms of what information should we regard as important enough or impactful enough on a person to warrant legal protection under privacy law, it is important, I think, to understand that privacy is understood deliberately expansively because there is such a broad range of factors that are at play in establishing someone's dignity, psychological integrity, well-being, ability to form relationships and maintain their image. It's deliberately nuanced, basically, and I think it does warrant a very broad scope of privacy law. In terms of why, I would say that the criminal law approach of not fundamentally distinguishing between manufactured and photographed images, why it's important that we extend that into a data protection context. I mean, there's a number of reasons, but I think the core reason is that criminal law focuses on individuals. Data protection law is often criticised in academic literature for being very individualistic, but if you compare it to other areas of law, data protection actually is much more systematic. It's much more focused on individual data subjects, but also organisations as a whole. It's about market regulation, it's about governance principles for organisations, it's about platform regulation, it's about quite a lot of other things, as well as individual rights. And I do think that makes data protection in many ways a much more effective tool and remedy for the type of harm I've described, because criminal law, obviously, as we know, it's very slow, it's very reactive, it has high evidential standards, and it mostly focuses on punishing individuals, the creator of the content, the sharer of the content, and obviously there are many scenarios in which that is entirely appropriate. If you have someone who has deliberately set out to humiliate or harm another human being, of course criminal law should be there. But if you're thinking about this as a systematic issue where you have large scale or at least the potential for large-scale uploads of non-consensual imagery, or at least images for which it is not possible to verify consent, which I would say under accountability principles that should be assumed to be non-consensual by default. Data protection is a much more effective tool in that scenario. It's accountability focused, meaning that a data controller is responsible for proactively demonstrating compliance. It's not enough to show that they are not breaching the law. They actually need to show that they are taking steps to ensure they're legally compliant. And to that effect, I think Pornhub do have a non-consensual content policy. And having looked at it, I'd have noted that it does already apply to both authentic and AI-generated intimate imagery. So there is evidence that these platforms, as data controllers, because they are joint data controllers with anyone that uploads content, that they are already pragmatically taking this approach. But I don't think we've quite, in data protection law and privacy scholarship, sorry, I know I'm nearly at 90 minutes now, I don't think we've quite done that conceptual work to catch up with where these platforms and AI generated imagery has got to yet. We've not quite expanded explicitly the scope of identification and relation to make it clear that something generated with AI can also be captured by data protection law and should be regulated as personal data. So unfortunately, I don't think I have time today to talk about digital twins and whether or not there are counter arguments about situations in which privacy law should treat AI generated avatars differently. I think possibly there's a slight modulation in how you would apply the accuracy principle, but ultimately my argument's technology neutral, and I don't think that even in a sort of digital twin scenario where there may be elements of consent to licensing a digital twin in the first place, for example, I would still say that the digital twin would be somebody's personal data and should be regulated accordingly. So I am well over time now, so I will stop sharing. But thank you very much for your patience and attention, letting me outline that. And I don't know whether there are any questions on that, but thank you for at least letting me have a go at setting it out.